Hi, in this video we're going to talk about the real estate code, specifically the parts about the real estate department and the Arizona Real Estate Recovery Fund. So when we talk about the real estate code, we're really talking about a body of law that deals with both the Constitution and Arizona statutes. So first and foremost, let's talk about Article 26 of Arizona's Constitution. Now, way back in the 1960s, the attorneys here in Arizona wanted to set it up so that only attorneys could prepare real estate contracts. That's the way it is actually in quite a number of states. But the real estate interest moved forward and put it out for a constitutional referendum, and the public voted for the real estate interest to be able to prepare contracts. So Article 26 to the Constitution was put in place. And what that article says is that real estate licensees may prepare all types of real estate contracts, not just a purchase contract or a listing, but leases, mortgages, options, all types of contracts relating to a real estate transaction. Now, obviously, this would not be a good idea for us as real estate agents to be preparing all of these contracts. So typically, what do we prepare? We prepare purchase agreements, listing agreements, leases, and a few other documents relating to those. However, there are restrictions or limitations on what we can do. First of all, the preparation of these contracts has to be incidental to our function as an agent for one or both of the parties in the transaction. So that's why I'm saying here it has to be incidental to our job. You cannot hang out a shingle, hang out a sign outside your office and say, we prepare contracts, so that a buyer and seller who've negotiated their own transaction can come to you and say, all we want you to do is prepare the contract. That's not allowed. And you may not charge for any contract preparation. So in a real estate transaction, a real estate company, a real estate agent is not allowed to charge any kind of a document preparation fee. So let's review this. Article 26 of our Constitution gives us as licensees the right to prepare contracts, but only when it's incidental to our function as an agent, and we may never charge for contract preparation. Now, another part of our real estate code is the Statute of Frauds. Now, in our contract session, we talk in detail about the Statute of Frauds. But what I want you to remember, what I want you to tattoo on the inside of your brain, is that when you see Statute of Frauds on the examination, the Statute of Frauds is what requires most real estate contracts to be in writing in order to be enforceable. So what's the Statute of Frauds? Contracts must be in writing to be enforceable. Now, most of our discussion within the framework of this real estate code will deal with certain actual articles of the Arizona Revised Statutes. ARS stands for Arizona Revised Statutes. And the real estate licensing laws are part of Articles 1 through 10, Title 32, Chapter 20 of the Arizona Revised Statutes. And in another video, I'm going to show you how to access any and all of the Arizona Revised Statutes, not just the ones relating to licensing of agents. The website you can go to is azleg.gov. That's the Arizona Legislature's website, where you can find any and all of the Arizona Revised Statutes. Right now, we're only going to talk about two portions of those today. We're not going to talk about, of those 10 articles, we're not going to talk about Article 6, which deals with cemeteries, Article 7, which is unsubdivided land. We're not going to deal with Article 8, which doesn't exist any longer, and we're not going to deal with Article 10, dealing with membership campgrounds. So we'll talk about articles in this little video here. We'll talk about Articles 1, which is the real estate department, and then Article 5. And in other videos, we will get into some of the other articles. Before we do that, though, we also want to make sure you understand that the Commissioner's rules, which are part of the Arizona Administrative Code, the Commissioner's rules, although not law, have the force and effect of law on you and me as real estate licensees. So once you sign up to become a real estate agent, please realize that the Commissioner's rules do have force and effect of law on us once we become licensed. And we'll get into the Commissioner's rules in another lesson. Now, if you'd like to have an actual book in your hand with many of the statutes and all the Commissioner's rules, I would suggest that you get yourself a copy of the Arizona Real Estate Law Book. All right, this is published by the Department of Real Estate and can be purchased through the Department of Real Estate, and it contains all of the licensing statutes, all of the Commissioner's rules, plus a number of other statutes. However, you can access all of these, of course, online at the legislature's website, as well as through just Googling Arizona Administrative Code for the Commissioner's rules. You can also access these through the Real Estate Department's website at azre.gov. Now, let's talk about Article 1, which is the Arizona Real Estate Department. So the Department of Real Estate is headed by the Arizona Real Estate Commissioner, and you should know what the Commissioner's qualifications and duties are. So first of all, the qualifications. The Commissioner is appointed by the Governor, so it is a political appointment, and the Commissioner must have at least 3 years administrative experience. In other words, he or she has to have run a real estate company or run some other business or office as an administrator for at least 3 years. And he or she must have at least 5 years experience in real estate or a related field. So many of our commissioners have been real estate brokers, some have been real estate appraisers, but they all have to have at least 5 years experience in real estate or a related field in order to qualify to become the real estate commissioner. The commissioner can also have no active real estate license. Now, a commissioner can put his or her license on an inactive status once they are appointed, but they can obviously not be involved with the day-to-day activities of buying, selling, leasing, and renting real estate. They have to be impartial, so they have to put their license on an inactive status. Now, what are the duties of the commissioner? The commissioner basically has 4 duties, and you can remember them by the acronym PIMA. PIMA, P-I-M-A, or if you prefer PAMI, P-A-M-I. All right, but using PIMA as our acronym, the P stands for promulgate, meaning promulgate the commissioner's rules. The word promulgate simply means to make official. So you could also think of the P as prescribe rules. So prescribe rules or promulgate rules, easy for you to say, is the first duty of the commissioner. Secondly is to investigate complaints against licensees. The commissioner must actually investigate any written and verified complaint against a licensee. The third one is to manage the day-to-day activities of the real estate department, and the fourth one, A, is to audit of the books and records of licensees. So let's talk about these more individually. The P for promulgate, meaning adopt rules through a public process. Please realize the commissioner just doesn't get up in the morning and say, okay, I've got a new rule today. The commissioner has to formulate those rules. Then the commissioner has to bring them to the Attorney General's office for legal review. And they also have to have public hearings relating to any adoption of new commissioner's rules. So it is a public process to adopt any new commissioner's rules. The I in PIMA, to investigate written complaints. So once the real estate department receives a complaint against the licensee, the commissioner has to look into that complaint, and if they verify that it's a legitimate complaint, then the commissioner has to have one of her investigators go ahead and take a look at what the situation was. Now, interestingly enough, many of the complaints that the real estate department receives have nothing to do with what the real estate department regulates. They actually have to do with customer service issues. One of the more common complaints against real estate agents, guess what it is? My real estate agent doesn't return my phone calls. So one of the important things is to keep in touch with your clients. That way they're not going to complain too much about you. But if it's a complaint relating to a real estate transaction that has substance, the commissioner must go ahead and investigate that complaint. The third duty is to manage the ADRE, to manage the day-to-day operations of the Department of Real Estate. If you want to learn more about the Department of Real Estate, of course, go to their website. And as a real estate agent, you will become very familiar with their website because of the fact that you will be doing a lot of business. You'll be doing a lot of interaction with the Department of Real Estate to become licensed and also then to renew your license. So the Real Estate Department's website address is azre.gov. The fourth duty of the commissioner is to audit, that's the A in PEMA, to audit the licensee's books and records. There are a number of different types of audits. Most of them are announced, where the department will contact the real estate company and say, we're going to set up a routine audit and we'd like to set a date and a time. Could also be unannounced. Hi, I'm from the Department of Real Estate and I'm here to help you. When the department visualizes a problem, a major problem, they might do an unannounced audit. So the four duties of the commissioner again: the P is promulgate rules, the I is to investigate complaints, the M is to manage the day-to-day aspects of the real estate department, and the A is to audit the books and records of licensees. In addition to the real estate department, there is a real estate advisory board. These are men and women who advise the commissioner and the governor on matters affecting real estate around Arizona. Now, the advisory board consists of 10 members. Their qualifications are 2 of them have to be real estate brokers, 3 of them can be real estate salespersons, 1 of which has to be in residential property management of multifamily units. 2 of them have to be subdividers, and the other 3 are public members. They could be attorneys or people from the mortgage business or the title business and so on. So 10 members on the advisory board. These members are appointed by the governor. They meet quarterly and they do not receive any compensation for their service. So that's the real estate department. Now let's take a few minutes and talk about Article 5 of the Arizona Real Estate Code, being the Real Estate Recovery Fund. The Recovery Fund is a last-ditch fund which compensates or may compensate consumers who are injured by a licensee's actions. Now, many real estate companies have errors and omissions insurance, but not all do. Errors and omissions insurance is not required here in Arizona. The Recovery Fund is a fund of last resort for the consumer. And what the requirements are for a consumer to be able to get paid out of the Recovery Fund is, first, from the time they feel they've been damaged, they have to file a lawsuit within 5 years. Secondly, they have to notify the commissioner within 45 days of beginning that lawsuit, and the payment out of the Recovery Fund is only made after that consumer wins a judgment in court against the licensee and the judgment is uncollectible. In other words, the licensee is broke and can't pay the judgment. Then and only then will the court order that the real estate commissioner pay out of the Recovery Fund. Now, there are limits on how much the fund will pay out. Per transaction or per cause of action, $30,000 is the maximum. So let me explain. Let's say that we had 4 different transactions in which Joe Bamboozler, let's say he's the licensee, who bamboozled these 4 different people or 4 different groups in 4 different transactions. And the first people to sue Joe win their judgment, let's say for $50,000. And the judgment is totally uncollectible because Joe Bamboozler is broke. The court will order the commissioner to pay out of the Recovery Fund not $50,000, but because it's one cause of action, $30,000. That's the maximum they can pay per cause of action, meaning per transaction. Let's say the group involved in transaction 2 lost $1 million. Well, the most they can get also is $30,000. Group 3 lost $500,000. The most they can get for transaction 3 is $30,000. How about the fourth group who lost $2 million? How much can they get? They can get nothing. Why? Because the fund has now paid out on behalf of Joe Bamboozler's misadventures a total of $90,000. Therefore, the fund is no longer liable for Joe's misadventures. So group number 4, they get nothing because the fund has paid out the maximum they can pay per licensee. So $30,000 per cause of action, $90,000 maximum per licensee. Now, if the recovery fund pays out because of a licensee's misadventures, that licensee's license is automatically revoked. The statutes say they lose their license. Question, can they ever get it back? The answer is yes, maybe. They may be reinstated, but only if that licensee paid back all of the money that the recovery fund paid out, plus some interest. In reality, however, the chances are slim that they would get their license back because of the fact, because of what happened in those transactions. So I only know of one person who ever attempted to get their license back after a settlement from the recovery fund, and they were unsuccessful. So, quick quiz. The Department of Real Estate exists to protect whom? Well, you got it right. Not the licensee, but the public. The public. So what the Department of Real Estate is concerned with throughout all of its activities is protection of the public. So how is the fund funded? How does the fund get its money? Well, this is going to cost you a few bucks. As a new licensee, when you originate your license, be it a salesperson's or a broker's license, as a broker, you're going to pay $20, and as a salesperson, you're going to pay $10 into that recovery fund. What happens if the fund dips below? And a few years ago, the fund did dip below $600,000. If in any year the fund dips below $600,000, then upon renewing his or her license the following year, each broker is going to pay an additional $20 into the fund, and each salesperson will pay an additional $10. Now, this has only happened once as long as I've been in the business, which is 40 some odd years. But please realize, initially the broker pays in 20, the salesperson 10, and as a stopgap measure to make sure the fund is whole, a broker would have to pay $20, a salesperson $10 to renew their license in the future if the fund dipped below this $600,000 level. So that's our discussion here on the real estate department and the recovery fund.